In less than a week, the Supreme Court will hear challenges to Texas's controversial abortion law. Arguments are scheduled for November 1st. The High Court is expected to decide whether the Justice Department has the right to sue Texas over the measure. It will also examine the law's method of enforcement by private citizens. Texas's law bans most abortions after 6 weeks, which is before many women know they are pregnant. The Supreme Court also ruled to keep the law in effect while legal proceedings are underway. CBS News politics reporter Melissa Quinn has been following this and joins me now. Melissa, thanks very much for being with us. Justice Sonia Sotomayor issued a partial dissent after the majority refused to block enforcement of the law. What more did she say in her filing?
Well, where Justice Sotomayor agreed with her colleagues was in their decision to hear oral arguments in both the case brought by the Justice Department and the separate challenge that was brought by abortion providers in Texas. Where she disagreed, though, is with their decision to allow this 6-week abortion ban to remain in place while this litigation plays out. What she said in her dissent was that the decision by the Supreme Court to hear the case offers, quote unquote, cold comfort to women who are seeking abortion care now. She also said that every day that the Supreme Court fails to grant relief to women in the state could be, quote unquote, devastating and have profound and immediate consequences.
Well, remind us of the legal challenges this law has faced since Texas first enacted it in September.
So the first lawsuit that we saw play out was brought by this group of abortion providers in the state of Texas. If you remember, before the law even went into effect on September 1st, this group of abortion clinics asked the justices to stop it from taking effect. And the Supreme Court ultimately, in a divided 5-4 decision, declined to do so. These abortion clinics then went ahead and returned to the Supreme Court this month and asked it to take up their case. And as you mentioned earlier, the key question there is whether or not the state of Texas can pass a law that is insulated from federal court review that seemingly denies a constitutionally established right. So it's really a procedural question at issue there. The second case was brought by the Justice Department several days after the Supreme Court in early December allowed this 6-week abortion ban to remain in effect. And as you mentioned, again, the key question there is whether the United States can even sue in federal court Texas and state officials and block enforcement of the law. I think it's important to note that in both of these cases, we're going to hear the justices try to wrestle with these procedural issues that are raised by this novel enforcement mechanism. The justices declined an opportunity from the state of Texas to go ahead and revisit its abortion precedents from 1973, Roe v. Wade, and 1992.
Well, you've spoken to abortion rights advocates about the effect this is having on abortion providers in Texas. How are providers navigating this new landscape?
It's been really tricky for them, and they're in sort of a wait and see mode while they wait for this litigation to play out. I spoke with Amy Hagstrom Miller, who is the president and CEO of Whole Women's Health, which operates 6 clinics in the state. She said 4 clinics. She said her 4 clinics and others in the state of Texas are in compliance with SB 8. But there was a 48-hour span in early October where a federal district court judge blocked enforcement of the law. And during that 2-day or so span, Whole Women's Health was able to see 6 women in all. The issue, though, is that there were very few physicians in the state of Texas who were willing to provide abortion services even while that injunction was in place. And the reason for that is that this Texas law allows for retroactive lawsuits to be filed against abortion providers there, even if they go ahead and perform abortions while an injunction was in place, which is what we had here, if that injunction is lifted in the future. So Amy Hagstrom Miller told me that she estimated less than 10 physicians who were willing to take that risk and see women during that 48-hour span that enforcement of the law was blocked.
Well, on Monday, Oklahoma's Supreme Court blocked 3 new abortion laws that would have restricted the procedure in the state. Oklahoma borders Texas. Could we see more women in Texas who are seeking an abortion cross state lines?
Yes, and that is something that is already going on. Amy Hagstrom Miller told me that there are clinics in Louisiana and Oklahoma both that are being inundated with women who are traveling from Texas across state lines seeking abortion care. She said that she's heard that clinics in both of those states are having 4 to 6 week waits. I also spoke with the senior counsel for the Center for Reproductive Services, which is litigating the abortion providers' challenge to SB 8. He told me that the issue with seeing this flood of patients leaving Texas is it not only complicates abortion care and access to abortion care for women in Texas who cannot receive that care while this law remains in effect, but it's also having an impact for women in those neighboring states who are now seeing their pregnancies progress and are also seeing their access to abortion care being curtailed because more and more patients are seeking care out of the state of Texas.
All right, Melissa Quinn. Melissa, thank you very much.
Thank you.